Okay, I think we are. One more thing. Mute me. There. Okay. Good morning, everyone. We have a mix of calendars, and we have someone from in Muskogee County who. Correll Turner or Dondre Frasier. Okay, we'll get there. We're gonna figure out who's doing what, and go from there. On the final plea calendar, Marquita Brown was a null pros from the state. Is that correct?
That's correct. Yeah.
Okay, I did that paperwork last night. I don't know if it's gone in. Was she brought over?
Yeah.
Okay, is she here?
Yeah.
Okay, I'll explain to her what happened, but we'll do that in a second. I just want to figure out what we're doing. Tyrus Brown, he's here. Great. Ms. Rios, your client?
Yes, sir. I just had to talk to him and relate the state's offer.
Okay, maybe a plea, maybe not. We'll find out. Corell Turner, right there. Good morning. And your lawyer, Mr. Patterson, is online.
Good morning, Judge.
Good morning.
And Yana, we would suggest, in light of information that came to light late last night in my office, we just need one more plea date so that my client don't lose the opportunity for this offer that was given.
Okay, we're going to come back to that in just a moment, and we'll see if we're going to do that.
Thank you.
You're welcome. Elijah Kitchens is here. Ms. Wood.
Yes, Judge. I anticipate this will just be the final plea hearing, but I do need to speak with him.
Okay, and he's a co-defendant with Mr. Turner. Got it. Okay. And then we have an inquiry calendar. Ms. Johnson is on. Is Mr. Hardwick here?
Yes, I'm good.
Okay, great.
Good morning.
Good morning. We'll work through that. You're trying to set aside a bench warrant.
Yes.
And I think this is one, Ms. Smith, where at one point, maybe there had been agreement, but you learned more information. There's less of an agreement. So we'll have that conversation. Is Ms. Johnson here? Great. So we'll do that this morning as well. Donnie Taylor.
Good morning, Your Honor. Mr. Taylor is present. Clarence Hollins on behalf of Mr. Taylor. It should be a quick announcement from the probation. We have an agreement to take on.
Great. We will tackle that. Dondre Frasier. Mr. Frasier, are you the one in Muskogee County Prison?
We're holding for Ricky Richardson.
Okay, but is that Mr. Frasier?
Yes, sir.
Yes, sir. Great. We're holding for your lawyer. And Ms. Smith, it sounds like this is something that's a plea this morning?
That's my understanding. Yes.
Okay. All right. Well, we'll see when Mr. Richardson gets here. And then Mr. LaChapelle, Mr. Aurora is on. We need Mr. Bridges for that, unless you all have someone else coming in, Ms. Smith.
I'll check on it.
Okay. All right. And then at 10 o'clock, I think we have a motions hearing, but it's not 10. So if you could bring Ms. Brown to the door, please. Sir speaking.
That's fine.
Hey, Ms. Brown.
Hi, Judge McBurney. Hola.
Good to see you.
Yes, it's a pleasure seeing you too.
Ms. Brown, I just want to let you know what's happening with your case. The prosecutor took a long, hard look at it and how old it was and what happened with the person you got in the argument with. And she, Ms. Smith, she's seated right over there, has decided to dismiss the charge. So I signed some paperwork last night that dismisses the case. And you ought to be, unless there's something else holding you, you ought to be released today, maybe tomorrow at the latest. You should reach out to Ms. Rios if it's lunchtime tomorrow and you're still in custody, okay? Do you have a safe place to go when you get out?
Yes, sir, I do. I've been doing good. I prepare my own rent, kind of stand to myself, going to the NA group. So I've
Good.
been doing well. My own business.
very cordial and respectful.
Excellent.
It's taught me.
Okay.
So God has been really good to me, and I appreciate the court still, looking forward and pushing me on and impressing me to do good in life and go on and do great things to stay away from looking at the house.
Good.
I've been doing a real good job with it.
Amen to that. You keep doing that and the future will be bright. I just want to let you know, we won't be bringing you back here and you ought to get released today if the paperwork is flowing smoothly. If not, probably tomorrow. Okay?
Gracias. Thank you.
All right. Best of luck.
Love your clients. You have the best.
All right, Ms. Lewis, you need to talk with Mr. Brown, so we'll circle back on that one. So Mr. Patterson, I'm gonna get you on the screen. And Mr. Turner, can you come on up to the podium, please? So, Mr. Patterson, what I heard you say is you very, very recently, last night, this morning, something like that, got some info from the state and you and Mr. Turner need a little more time to work through that so you can counsel him in person, et cetera. Is that a fair summary?
Well, actually, the information came from my client, not the state, but as a result of that information, I don't want to miss out on an opportunity because I think after today, if we turn the offer down, everything else is a blind plea. Is that correct?
That is correct. It's non-negotiable. I mean, you guys could negotiate, but you're right. He cannot withdraw, right?
Absolutely. And that's why I need one more opportunity based upon the information my client gave me last night to negotiate with the prosecutor without having to turn down this offer.
Okay, and so you would be then meeting with Ms. Smith. So I got who's going to be meeting next wrong. You'll meet with Ms. Smith to share with her what your client shared with you, which presumably is something in mitigation.
Correct.
Got it. Okay. Ms. Smith, my proposal is not to set another final plea date, but the trial date for this case is late April. Okay. And I would just preserve Mr. Turner's final plea rights so that if you and Mr. Patterson reach an agreement on or before that day when we call the calendar, Mr. Turner would still have his final plea rights. Is that all right by you?
Yeah,
that's perfect, Judge.
Okay. Mr. Turner, did you sort of follow what we were talking about?
Yeah.
What do you think's happening?
Like when I talk to my lawyer?
You're going to talk to, it sounds like did you talk to your lawyer some last night?
Yes.
Okay, he's going to talk with the prosecutor who's seated behind you and see if he can sort out a situation for you.
Yes.
You will have the ability, if you decide to enter a plea rather than go to trial, you and your lawyer will tell me everything about your case. I'll hear from the prosecutor. And if for some reason I disagree with what your lawyer recommends and I sentence you to something more severe than what Mr. Patterson asked for, then you'll have the ability to withdraw your plea and say, you know what, I was willing to do X, but you did something different, Judge. No thanks, I'd rather go to trial. So you're preserving that right. After this last day of April 23rd, you can always enter a plea. You could enter a plea in the middle of your trial. You just don't get to withdraw your plea if you don't like the sentence you get. Do you understand that?
Yes, sir.
Okay. Do you have a good way of reaching Mr. Patterson?
Yes.
All right. Let me ask you a couple more questions. The address that we've got for you is, I don't know how to pronounce it, Guelph Circle?
Golf.
Okay. It's not spelled like golf. That's still a good address for you in Hampton? All right. And bond, your bond order, you've got an ankle monitor on.
Yes.
Okay. You're still complying with all those conditions?
Yes.
No issues with those?
No.
Okay. Let me see. This is a funky bond order. So you're staying out of Fulton County except to visit your lawyer or do you go to school right now?
School and work.
Yeah. Okay. What's your job? Are you school or work or both? Where are you in school?
Getting back into Atlanta Tech, but I want to switch to UEI.
Okay. And what is your job?
My job is working, I applied to Walmart, but I'm working with my cousin as of right now for junk removal.
Okay. All right. It sounds like you understand what you need to do with bond. Make sure you keep doing that. And I think we've covered it, Mr. Patterson. Anything else?
That should do it, Judge.
All right. Hope it don't rain on you today.
Thank you. I'm in Tifton, Georgia.
Oh my gosh. Well, you get a very good signal coming from Tifton. Thank you for dialing in.
Thank you.
All right. Bye-bye. And Mr. Turner, you are good to go. Mr. Patterson will be in touch with you after he talks with the prosecutor.
Okay, thank you.
You're welcome. So, Ms. Wood, do you need to talk with Mr. Kitchens first?
Quickly, whenever the deputies are ready for me to go back, Judge.
Okay. I don't know if they can have you back. We could have Ms. Johnson come out and handle Mr. Hardwick and Ms. Johnson's situation. I don't know if you can be back there at the same time, but we'll keep moving forward. All right. If we could bring Ms. Johnson out, please. Hey, Ms. Johnson, if you'll come up to the podium, please, and stand next to your lawyer. I'm just looking for one document and then we'll.
Last year.
It was in June
Of 2025.
2022. I got out. Gave us everything.
That's the one improvements. But you were living in Atlanta then, right?
Yeah.
All right. Let's get on the record. Good morning, Ms. Rivers.
Good morning, Judge.
You ready to go forward?
Yes, I'm ready.
Great. This is position 1 on our inquiry calendar. It's 24 SC 000-602. State versus, is it pronounced Raina?
Yes.
Raina Johnson. Ms. Johnson is here with her lawyer, Mr. Hardwick. We have Ms. Smith for the state and Ms. Johnson. Mr. Hardwick filed an emergency motion to set aside a warrant that I issued a long time ago. I think it was back in March of 24. You missed a court date, or you weren't here for a court date. I think to get your case started. And because you weren't here, I issued that warrant. That warrant has eventually caught up with you. You are in custody now. And Mr. Hardwick is going to tell me why I ought to set that aside and get you back out on whatever bond you originally had in this case. Ms. Smith, the prosecutor, I think has a different view as to what should happen. She's going to talk to me about it as well, and then I'll let you know what I'm going to do, okay? So really all we're talking about is this bench warrant, not the facts of your case or anything like that.
Yes, sir.
All right, Mr. Hardwick.
Judge, it is very, very important to know that in my 50 years of practice in law, I have represented a number of clients that have been charged criminally. I have never had a client that has been more aggressive and more fastidious in terms of checking with me, checking with the office, checking the court docket to determine when she was required to come to court.
So I'm sorry to interrupt. So you've been working with Ms. Johnson since this case originated?
Exactly.
Okay, because you are not, and it may have been when it was just an arrest or something. You're not there's no entry of appearance from you. So I'm not doubting that you've been involved. That's news to me. I thought you were brought in because of this crisis.
I entered an appearance on her behalf at the time that her original bond was set.
Okay.
And obviously that did not make its way over to the clerk's office here, but I have represented her. since 2022.
Okay.
Okay.
Just how old this is.
I encouraged her to do a change of address, which she did. She is telling me it was done in 2024, but it was in June of 2024. The court notice, as per the information that we were able to discern, went to Warner Robins, Georgia. She has been living in Atlanta since.
The court notice went to the court
How long have you been living in Atlanta?
since 2022.
Since 2022. So I don't really know where the discrepancy lied, but what's important, Judge, is to understand that there was no effort on the part of this young lady ever to avoid coming to court.
Ms. Johnson, I don't have an Atlanta address. I have a Fairburn address. Is that what we're,
Yeah,
I mean, it's close enough, but it's not Warner Robins. It's in Fulton County.
Right.
So the Apple Mist Drive,
Yes, sir.
that when we're talking about Atlanta, we're talking about that address.
Yes, sir.
And you're saying that since 2022, sometime soon after the allegations that this case is all about, you were at that address, or were you even at that address back when this situation happened?
Yes, sir.
Which one?
When the situation happened, I left the address temporarily.
But the address we're talking about is the Apple.
But I'm back there and I've been back there since.
Okay, so when this situation happened, whatever happened, you were not in Warner Robins.
No,
Okay. All right.
Well, she's a career, how many years in the service?
20 years Army.
She's a career military person. And again, it's just very unfortunate that this happened. But Judge, I can state unequivocally that it was a mistake, and she is the last person that would try to miss court.
The only notice I've been able to find that was sent out to Ms. Johnson saying you need to come to court on March 18th, that's the date you weren't here, was sent to the Armed Forces Boulevard address in Warner Robins. So the document I've got supports what you're saying, that if you were at Apple Mist, you wouldn't have received notice. Who would have been at that Armed Forces Boulevard? It's an apartment. Who would have, at some point you lived in that apartment?
Yes.
And when did you move out?
I moved out in, I want to say March of 2022.
Okay.
And I was transitioning from the military. So from March of 2022, that's when I left that Warner Robins address.
Okay. And the incident was in May of 2022.
Correct.
Okay, got it. All right. Mr. Hardwick, I know I have paused you a couple times just because I had questions. Was there more that you wanted to share?
No, Judge.
Okay, all right. Ms. Smith, tell me the state's concerns about setting this aside. It looks like, from what I can find, you may have more, that Ms. Johnson didn't have notice.
Yes, Your Honor. In this case, the state's main concern is that because the defendant was missing from prosecution for around 2 years, the state does not want to again lose her or not be able to get in contact with her if she is released. We do believe that the charges in this case are serious, so we want to be able to get a chance to resolve those cases and not delay the judicial efficiency process that we're doing here. We do believe that there was good notice. However, if the court is inclined to set aside the bench warrant, the state would ask for some type of ankle monitor or something like that so we can ensure that the defendant is able to come back and we know the location of the defendant while we're trying to resolve this case.
Okay. Ms. Johnson, how long have you been in custody?
4 or 5 days.
Okay. How did you come to be in custody?
Well, I was driving down the street and an officer was behind me. He ran my tag according to him and he pulled me over and he said, there's an active warrant.
Okay.
For your, and I said, again, it threw me off because.
It's old.
And yeah. So That's how I got. But I definitely wasn't trying to avoid the courts, wasn't trying to avoid anything.
Are you working? I mean, not working right this moment, but are you working now or are you retired? I know you're retired from the military. Are you retired?
Well, I have a part-time
And what's that?
Amazon.
Okay. Meaning you deliver things or you work in a warehouse?
In a warehouse.
Okay. And at the Apple Mist address, who lives there with you?
Tracy Smith.
Okay. Not whoever the alleged victim is in this
No,
case.
she no longer there.
Okay. She was, at one point, you both were at Apple Mist.
Yes,
She's gone from there. You're there and Ms. Smith is there.
Mr. Smith.
Mr. Smith. Okay. Does Mr. Smith work?
Yes,
What does he do?
he's a GM for DHL.
Okay. All right.
For the court's edification, the complainant is the sister of Mr. Smith.
Okay. All right.
And Judge, if I might, I would strongly oppose the implementation of an ankle monitor or any type of device. And the only correlative relationship between the time is the fact that the court appearance was in March of 2024. It could have been last week or 2 months ago. The lack of knowledge would have been the same. And so I don't think that we should approach this in a punitive way based upon the passage of time. Her behavior is not in any way correlative to anything other than the fact that she simply didn't know that she was supposed to be in court.
Okay. No, I hear you. And I don't hear Ms. Smith saying anything about punishment. I hear her understandably saying, we want to make sure something like this doesn't happen again. And one way to have a pretty good idea of where Ms. Johnson is would be to have electronic monitoring on. I'm not saying I agree or disagree, but I am pushing back on the notion that it would be a county-funded monitor to begin with. It would cost $0 for Ms. Johnson, but it's this thing on her ankle. It's obvious. People see it. What's going on? There's a stigma associated with it. So I'm not minimizing the impact of it, but I don't view it as punitive. I view it as reassuring to the system if there's a concern. I don't have that concern, however. And so what we need to sort out is whether there is still a bond in place. This case is so old, I don't know if the bond was surrendered. I don't actually see,
I spoke with, it is Tracy Smith that posted the bond. He was the person who contacted me upon her detention in Douglas County and upon her subsequent arrest. I have been in constant communication with him. The bond is still in place.
Okay. I'm going to need to modify it because it says stay away from Apple Mist Drive. And you're doing a bad job of that because you're living there. But if Ms. Nelson isn't needing to be around there, I don't want to create a situation where she feels like she cannot go back to a family residence or whatever her connection is to that. Because the charges are on Ms. Johnson and not Ms. Nelson, it's Ms. Johnson who would need to not be near that address. Can you, Ms. Smith, speak to that dynamic at all? Do you know if Ms. Nelson actually, if Ms. Johnson weren't around, would be living at Apple Mist?
I'm not too sure about that, but I can't look into it, Your Honor.
Okay. Well, you can tell your lawyer, if you know, it'd be helpful to know Ms. Nelson's situation.
I've been informed that her brother, Mr. Smith, informed her that she had to leave following this incident, and she has never returned.
Okay. So Apple Mist Drive is Mr. Smith's house, and he can tell people to stay or go. All right. Well, Ms. Johnson, we need to do a few things today. Mr. Hardwick, you need to file an entry of appearance. I think there's a form right there for you to do that. I know you said you've done it before. I need it in our docket.
Sure.
I also want you to either waive arraignment for your client, another form right there, or we need to formally arraign your client so that I can get a scheduling order in place and we can move this forward. I'm sure she wants closure, and that's what I heard Ms. Smith saying.
And I have, first of all, I need to say, I want to say to the court that Ms. Smith has been incredibly cooperative in terms of trying to facilitate this appearance today, and I very much appreciate that. She even indicated that based upon the circumstances that she and her supervisor had even reviewed the case and were prepared to even present an offer to us. So we'll have to sort of work through that. So the process, I think, will move forward very, very quickly.
Great. And if for some reason it doesn't, my scheduling order will make sure that it moves forward. But I can't put that in place until you fill out the waiver of arraignment form and we get your entry. But once you do, we'll get things moving. I will modify the bond only to remove the condition of the stay away from Apple Mist Drive. Right. Ms. Johnson, you will need to continue to have no contact with Ms. Nelson. And so if for whatever reason her brother says, hey, I'm going to have a meal with my sister, you can't be involved with that meal. It's important to keep the two of you apart, you and Ms. Nelson, until we resolve this case. And I have a chance to hear from the prosecution, or maybe even from Ms. Nelson, her perspective on, you know what, just no violent contact, or nope, I never want to see Ms. Johnson. But today's not the day we work through that. We keep in place that requirement that you have no contact. So if for whatever reason she shows up at the Apple Mist address, you would need to leave that address while she's there.
Absolutely.
Does that make sense?
Yes, sir.
Okay. Any other questions?
No questions.
Okay. Mr. Hardwick, anything?
Nothing further, Judge.
Ms. Smith?
Nothing further, thank you.
All right. Mr. Hardwick, if you would fill those out before you leave today.
I will do it right now.
Great. And just get them to Deputy Gordon. We'll get them filed and that'll get things moving. Ms. Johnson, I'll sign some paperwork that sets aside the bench warrant. It's early enough in the day. You may get out today. I don't want to overpromise. You ought to get out tomorrow at the latest, okay? If it's lunchtime tomorrow and you are not out, you will continue to be that responsible client and bother Mr. Hardwick so that he can reach out to say, what's stuck? All right?
Yes, sir.
Thanks, everyone.
Thank you so much, Judge.
Oh, yeah. Do you need a black thing? Oh, wait, use this one. Okay, that's okay.
Okay. A CV. Okay. Thanks. Ms. Nelson, do you have any update on Mr. Richardson? Would he be appearing in person or virtually?
He was on his way down, Judge. He said he'd be about 15 or 20 minutes late.
Okay, great. We will keep on. I don't want Muskogee to be stuck for too long, but if he's on his way, that's good. I think what's up next is Donnie Taylor. So Mr. Taylor, if you can.
I think just
I can go grab. Okay, that's the probation officer who's working with him? Okay. You may want to be there for that conversation.
And I didn't look at the police report. She said right there.
And we appreciate you getting on this on the calendar, Judge. I know a little
problem.
bit last minute.
Are you Officer Middleton?
Yes, sir.
Excellent. Okay. Need you guys to switch sides. Great. Let's get on the record in your case. It is 14 SC 127639. You're Donnie Taylor. Mr. Hollins is representing you now.
Yes, sir.
Ronnie Poole was the lawyer way back in 2015
Yes, sir.
when you entered a plea in this case. But you've got Mr. Hollins now, which is great. And he has been very proactive to get you in here. I have a petition I signed. I guess there's not a warrant yet associated with it, just a petition.
We withdrew the warrant in light of
The walk-in. Okay, that makes this easier. But Officer Middleton presented me with a petition that suggests you violated the terms and conditions of your probation. Specifically, the allegation is that in November of last year, you were arrested for simple assault here in Fulton County. Getting arrested is a violation of probation. That's less serious than if in the end you're convicted of it, either because you plead or you go to trial. But we'll need to work through that situation because getting in trouble, as I call it informally, is inconsistent with being on probation. So what I'm going to do is hear from your lawyer first. I may have some questions for him or you. I won't be delving into the facts of your case if you haven't resolved it yet. But I'm going to need to understand a little bit about that situation. I may ask Officer Middleton some questions since he's been working with you. And then I will also hear from Ms. Smith. Are you managing this one?
I am.
I'm going to hear from Ms. Smith. Okay. But I'm going to start with you, Mr. Hollins. Tell me what's going on with Donnie Taylor.
Yes, sir. So Mr. Taylor was I want to say involved in a situation, but in my opinion, not really involved. There was a situation that happened between two other individuals, two sisters, I believe, and one of the sisters was arrested. Subsequently,
these are sisters of each other, but also sisters of Mr. Taylor?
No,
sisters. Strangers to him, or he knows them and knows their sisters?
He knows them and knows their sisters.
Okay,
yes, sir.
So sister one and sister two get into it.
Yes, sir. So we'll just say sister one gets arrested, okay? Sister one subsequently swears out a warrant in Fulton County Magistrate Court in which Mr. Taylor was the defendant in. He was taken into custody after, I guess, there was a probable cause finding that there was sufficient evidence. I have spoken with Officer Middleton. As I understand, Mr. Taylor has been in a model probationer, as I understand, has not been in any other trouble. And as a result of it, we are asking that he be allowed to continue on probation, as it seems to me that this situation he was kind of put in there and didn't need to be put in there. And so we do plan on eventually working out the magistrate warrant or I guess if the state decides to bring the case in state court, I will represent him and handle that. However, in my opinion, it doesn't seem to be that Mr. Taylor was at all the aggressor in that situation and should not have been arrested.
And the solicitor's office may not do anything with this?
Correct. Yes,
okay. Sir. And as far as you know, to date, they have not. There's not an accusation.
That is correct, Your Honor.
Okay. All right. Officer Middleton, in looking in the docket for Mr. Taylor, this is the first entry in a decade. There was something that was put under seal in March of 2016, which was a few months after he pled. And then there's this. How long have you been working with Mr. Taylor?
Good morning, Your Honor.
Good morning.
Yes, I've been working with Mr. Taylor since 2016.
Oh my gosh. Okay. And?
This is the first incident that I experienced with him.
Okay.
Throughout the years, he's been in compliance, been reporting, no positive drug screens. She's been abiding by all his conditions of his probation.
Okay. Do you have any concerns about the recommendation that Mr. Hollins is making, that we see this as a hiccup? I'll tell him you just got to be thoughtful about situations you find yourself in, and then we move forward. Okay. Ms. Smith, have you had a chance to either talk with Officer Middleton or Mr. Hollins or think about the situation?
I have thought about the situation. I didn't get a chance to speak with them, but based on what I've heard and from the officer also, I wouldn't be opposed to continuing probation in this case.
Okay. Officer Middleton, are there any special conditions? I know he's registered, but beyond that, is there anything that persists? He's done, if there was community service, he's done that. I mean, he's being supervised.
He does have treatment.
Okay.
So he's complying with treatment.
Good.
That's the only condition that he has at the moment.
Okay. Well, Mr. Taylor, anything you want to add?
No, sir.
Are you working?
No, sir.
Do you get benefits?
A disability.
Okay. And is that enough to make ends meet? You got a little side hustle? What's going on?
No.
You dress nicely and everything.
Thank you, sir.
Okay. Benefits are enough to make that work?
Yeah.
Okay.
You know, they locked me up by mistake.
and he tried to take my son to custody. I got a 2-year-old son, and then he tried to take my son to custody.
You're saying as a result of this?
Yes, sir.
Okay. Well, Mr. Hollins is helping you navigate that. And when you say they locked you, there was a warrant for you. So I'm not blaming the police who locked you up. The young lady who swore out that warrant, there may be an issue there if she's trying to deflect. She's the one who was arrested for this fight. You know, the real villain is Donnie Taylor. And it's easy to pick on someone in your situation because the police look you up like, oh my gosh. I wasn't there. I'm not taking sides. But I do want to push back a little bit on this notion that I was wrongly arrested. If the police are handing a warrant for you, they got to pick you up. The issue was with the warrant process.
No, I went to court. I had to go to court. They didn't know I had a court date.
Okay. Well, it sounds like some of that's behind you. I'm not going to change anything with your probation other than note that this happened and you've got, how much is left on probation? You got some time left. So if you and Mr. Hollins and Officer Middleton and I are getting together again in a couple of years, this is sort of like your first offender. We're going to say, this is one where factually there may have been nothing that happened, but you did get arrested. That's a little bit of a bump for someone on probation, especially with your charges. But because you've been doing well, you've earned the goodwill of Officer Middleton. I think it makes sense to let's just press forward and you rely on Mr. Hollins to navigate this warrant situation. Don't take matters into your own hands. And you have a 2-year-old son?
Yes, sir.
And he stays where?
She with his mama.
Okay. And his mom local?
Yeah.
What's his name?
Zaire Taylor.
All right. Well, congratulations on having a 2-year-old. How often do you see him?
I see him twice a week.
Okay. Well, good. All right. Well, anything else, Mr. Hollins?
Nothing from the defense, Your Honor.
Ms. Simpson, I haven't really done one like this. So we have a petition and then do I sign something saying we heard it and I acknowledge it, but there's no change in conditions? What do we do?
I can submit a revocation and just check off the section that says official was continued. I didn't know time was revoked.
Okay. No time is being revoked. So I guess we need to, the docket ought to reflect that we dealt with the petition. So let's do that.
So then, yeah, I'll just do the revocation order and it'll notate that no time was revoked and the person is continued.
Okay. Sounds good. Anything else, Mr. Hollins?
No, sir.
All right. Officer, thank you for being here. Appreciate it.
And that concludes our business, Judge. May we be excused?
Yep.
Thank you, Judge.
You're welcome. Mr. Richardson, your timing as always is impeccable. Next up is Dondre Frasier. Do you need time to speak with Ms. Smith before? He's on from Muskogee.
We haven't worked out. We need to approach the court. Just in terms of, just kind of a quick background. Mr. Frasier was under sentence on aggravated assault in Fulton County. He was shipped into the system somehow. This is about the time that Mr. Derek Wright, who was his lawyer, I believe had his health problem. So he was in the system. This case wasn't taken care of, run concurrent with his other case. The other case was a 10-year to serve 7.
Okay.
Okay. The court placed a judicial hold on him, I believe in June of 22, maybe 23. Okay.
Okay.
In the interim, he just was there. He had a problem in Tennessee. They took him to Tennessee. Did that.
I'm remembering him now that because of the Tennessee piece.
Brought him back to Georgia. And so he's now approaching probably year 5 or 6. And it's close to time to leave. His family, and he contacted me. He said, look, I don't want to get out and have to face Judge McBurney. And have to go, start all over again.
Okay.
Maybe get this down while I'm in custody.
Yep.
The state has recommended a 5 year to serve 3. What I want from the court is from the date that the warrant was, the hold was placed on him, they get credit from that time. It ended up being a time served in terms of 3 or whatever balance is left on 5 on probation.
So I think statutorily he is entitled to all the time he's been in. When 17, 10, 11 or whatever it was amended, any time in custody after these charges were brought, he gets credit for whether it's in Tennessee or here. And it sounds like he's banked more than 3. So I don't think I would have to sentence him to more than the time he's been in to extend his sentence. So if the state is asking for 3, I think he is protected is a weird way of putting it, but he's earned the 3. He served the 3. And so there might be a period of probation that would carry over beyond his parole date, but I don't think that's a bad thing. Okay?
I think he has 10 years behind him, but he has 3 years more behind after the 7 is satisfied.
Got it. So this might even expire before the 3 would expire. It would just run concurrently with it.
So with that being said, I'm not sure if there's a way to speak with him, just in a,
There is, if you could get on the Zoom on your phone or your laptop, you can go into the jury room and I'll put the 2 of you in a breakout room.
please, if you give me like 5 minutes to set up and I'll be ready.
Easy to do. When I see you on the Zoom, we'll do that. But before you go in there, if you could just come to the podium so Mr. Frasier can see you. Mr. Frasier, were you able to, Mr. Richardson was not near a microphone, but we just spent the last 5 minutes talking about your case. Were you able to hear any of it?
Yes, sir.
Okay. Mr. Richardson is going to hop on this Zoom call. He's right here. You can see him on the screen, but he wants to speak with you privately. So he's going to go into the jury room and get on Zoom, and then I'll move the 2 of you into a breakout room, which is a private space. No one else can hear you, just so he can let you know what's going on, make sure you're good with that. When he comes back out here, we'll knock out this plea. Does that make sense?
Yes, sir.
Okay. So if you sit tight, when I see Mr. Richardson on the Zoom, I'll move you both into that breakout room. All right.
Judge, can Mr. Richardson provide the case number that he is currently serving under?
Okay, I'll get that for you in just a moment.
He will get that for us.
Thank you.
You bet. So I think all that's left is people who need to talk to their clients. Have you had a chance, Ms. Rios, to speak with Mr. Brown?
Yes, Your Honor, and we are gonna go to move on to the trial calendar, and the state agreed to keep his final plea rights open. I just now relayed the offer. We're gonna continue to negotiate.
This is for Mr. Brown.
Yes.
Okay, Mr. Brown, where are you? Hey, so let me see if you are on the same. You are. All right. So your trial date is April 23rd. Sometime.
I think you can still have a leave for that date, but I guess she has a move date.
Oh, here, look, there's this leave of absence sitting in the docket. Yeah, you do. Okay. Well, this just means you should work it out before you go. So, Mr. Brown, you and Ms. Rios are going to sort your case out before this trial calendar. But what I'm going to do is preserve your final plea rights. And you may have heard me talk about it with the actually gentleman who's seated right in front of you. As of today, you have the ability to enter a plea. But if the sentence I impose is more severe than what your lawyer asked for, you can back out of the plea. You asked for 2, I give you 3. Judge, I was willing to take 2, not 3. No, thank you. After whatever day we agree on, and it's probably going to be after this trial calendar because Ms. Rios is not going to be available then, you'll reach a point where if you haven't worked your case out, then you lose that right to withdraw your plea. But we're not there yet. I don't know when that day is going to be. But in the meantime, you need to stay in touch with Ms. Rios. Do you have her number? Okay. Does she have your number? Your bond says you have to stay away from a Maria Howard. Do you know who that person is?
Who's here, Your Honor?
Okay, she's right there. Have you been staying away from Ms. Howard? Okay, then you've been doing what you need to do. Ms. Howard, do you feel like Mr. Brown has been having contact with you? No, he has not. Good, then he's doing one of the things he needs to do. So you remain on bond. You need to have no contact with Ms. Howard. You need to have lots of contact with Ms. Rios as she is trying to help you sort your case out, okay? Any questions? Ms. Smith, anything from the state?
No, Your Honor.
Okay. Anything else, Ms. Rios?
All right, thank you.
All right, Mr. Brown, we will see you maybe on April 23rd, maybe not. You'll get notice.
Wait, just one down here.
Judge McBurney, can I say one other thing, please, related to Ms. Johnson?
Yes. Well, Ms. Smith isn't here, so we can just wait till she's back in here to hear it. Thanks. Oh, she's in the middle of a conversation, so let me hear from Ms. Rios. You want to leave? Okay, yes. You leaving for your leave?
No.
No, you'll be back?
Well, honestly, we'll have to figure out other plans because all the stuff going on. We're gonna go do with like downstairs. So,
Well, maybe you'll be here then.
well, I think there's one else.
Oh, well, dang, okay.
Maybe not over there.
Just not over there, okay. It's probably okay to go to Italy, but that's your call, not mine.
Through Istanbul.
Oh, Istanbul, oh,
Bombing Turkey, so.
okay. Maybe Detroit.
Oh, my God.
Why would you suggest it?
Well, that's where my brother lived. It was all right.
But that's, maybe some more study.
Okay.
Like, produce it down on boats.
All right. Yeah, they're torpedoing boats now. It's not a safe bit. Ms. Smith is back. Mr. Hardwick.
Judge, I just wanted to point out, and this is really much more relevant in terms of getting Ms. Johnson out of the jail scenario. I shared with Ms. Smith on yesterday something that is quite personal to Ms. Johnson in that she recently had major female-related surgery. She had a relapse almost days before her subsequent arrest. And so she is in need of
Medical care.
yes.
Got it. And you would put that in your motion. I didn't want to air that out. I was going to let you do that. I was aware of that. Another reason to reconnect her with her home and whatnot. But she should be out today or tomorrow, and then hopefully she'll be able to get the attention she needs. All right?
Thank you, Judge.
You're welcome.
Thank you again.
No problem, see you soon.
All right, I don't see Mr. Richardson on yet, so I can't do that. Ms. Wood, you need to talk with Elijah Kitchens.
I've already spoken with him.
You already spoken with
We're
him.
ready for a final hearing, Judge.
Okay, can we bring Mr. Kitchens out? Good morning, Mr. Kitchens. If you just come stand right next to Ms. Wood. How you doing?
No good.
Good. We're going to get on the record in your case. It's 25 SC 005 882. And you're Elijah Kitchens. Your lawyer, Ms. Wood, is right next to you. Ms. Smith is the prosecutor on your case. And I'm going to ask your lawyer and the prosecutor a few questions and make sure you're following what we're doing. Ms. Wood, do you feel like you've got all the discovery in this case?
Yes.
All right. Ms. Smith, if Mr. Kitchens wanted to resolve his case today, what would the state's offer be?
The state's current offer is 15 years to serve 10 with the balance probated.
And is that to the armed robbery charge?
Yes, Your Honor.
Okay. So, Mr. Kitchens, if you were inclined to enter a plea today, the state would recommend what's really the minimum they could recommend under these charges. Armed robbery is 10 to 20 or life. So they'd be recommending 10 on the armed robbery, and then there's a firearm charge that has to run consecutive. That gets us to the 15. But they're saying those additional 5 years would be probated. So 15 to serve 10, balance probated. Of course, with armed robbery, those years are not prolongable. So it would be 10 years to serve. Do you feel like you understand what the state's offer is?
I understand.
Okay. Is that anything you're interested in pursuing? Okay.
Yeah.
And I understand that. Here's what changes after today. Two things one changes for sure, one may change. The for sure change is that after today, you can still enter a guilty plea, but what you will not be able to do is withdraw it if the sentence I give you is more than what Ms. Wood asks for. Today, she could not ask for less than what the state offered, so you'd be kind of stuck. But let's fast forward 3 weeks, you say, man, I want to plead guilty, and let's do that 10. And Ms. Wood says, you should give Mr. Kitchens the 10. And I learn about the situation and learn about you, and I say, I think it should be 12. Today, you could withdraw your plea and say, I was willing to do 10. I'm not willing to do 12. After today, you can still enter a plea. You can always enter a plea. You just don't get a step back from it if you're unhappy with the sentence you get. I don't share that with you to say I would disagree with Ms. Wood. I might say, yep, that's the right sentence. But if I did and I sentence you to more than what she asked for or more than what the prosecutor asked for, those two sides may agree and say, this 15 to serve 10, Judge, we're sticking with it. I'm not bound by that. Do you understand that?
Yes, yeah.
Okay. And here's the thing that may change. I don't control this, and nor do you. The state's offer today is the lowest, that 15 to serve 10. Tomorrow or a month from now, they may have a different offer, and you don't get to say, wait, you told me 15 to serve 10. That's up to Ms. Smith whether she keeps that offer open. And she's not going to be coy about it. Ms. Wood can talk to her. Ms. Smith will say, sure, we'll leave it open for 2 more weeks. We'll leave it open until the trial date. But you just need to understand that that's not a forever offer that you could just on any day select. Understand that?
Yes, Your Honor.
All right. I'm going to move your case to the trial calendar. It's on April 23rd. That's the day we call the calendar. That's not when the trial starts. So at the latest, you'll be back here on April 23rd. You may be here before then. If you and Ms. Wood sort something out and we can handle this by way of plea, we'll get you here before the 23rd. But at the latest, on the 23rd, we'll be here to see if it's worked out. And if not, talk about, are you going to be the first week or the second week of the trial calendar?
All right.
All right. Ms. Wood, anything else on behalf of Mr. Kitchens?
No, Judge, thank you.
Ms. Smith?
No, Your Honor.
All right. We'll see you soon, Mr. Kitchens.
See you soon. Have a good day. May I have your excuse, Judge?
Yes.
Thank you.
Can you check with Ricky Richardson? He's Mr. Richardson to see if he's got some other name he's on.
Must be nice.
He said he needs the Zoom.
Oh, the Zoom link. All right. That would help. And Mr. Aurora and Mr. Bridges, we're going to turn to La Chapelle next. I just got to get this to Mr. Richardson.
Judge, I'm sending it to him. I just talked to him.
Oh, thank you.
Mhm.
Then we can do La Chapelle now. Let's see here. For spotlight. And Mr. Bridges, can you power up your camera, please? Miss Shields. Hey, I'm Judge McBurney. Your case has been assigned to me. You've got an emergency motion. As you can see, I'm doing some stuff. The judge who is on duty is Judge Edwards, who conveniently for you is right next door. And so what you need to do is check in with her team. So if you go next door, there should be a deputy in there, and you can give them your case number and let them know that you came by my chamber, well, came by my courtroom, and I'm in court right now. And so I asked them to take a look at the situation. They're going to look at it and decide, is it really an emergency? And if it is, that judge's job today and tomorrow is to handle the emergencies. If they say it's not, they're going to send you back here, and we'll figure out a time next week when we can talk about your situation. I haven't had a chance to read any of the documents, so I don't know if the writ of possession or the lien is tomorrow, or clearly it's urgent because you're here and you filed some things. But when there's an emergency like that, our what we call our presiding judge, and it rotates every week, often is tasked with handling that. And this week it's Judge Edwards, who's next door. So they're going to say, wait, did you talk with Judge McBurney? And the answer is yes, you did. And I asked them, because I'm in court now, to take a look at your case. And if they determine that it is an emergency, then they can try to tackle it. One last thing I'll add, and I'm going to turn to what I'm doing right now. The judge or her staff attorney may say, we don't do things ex parte, meaning talking just to you. Jack Bilt is on the other side. And so they may say, you have to give them notice that there's going to be a hearing on your emergency motion, which means you call the person you've been dealing with, or if they've got a lawyer or something. Judges are, I think you could understand why, reluctant to just hear one side of the story and say, oh my gosh, Jack Bilt's terrible because you said so. $100,000 for Ms. Shields. And that's not what you're asking for. But generally, we try to get both sides in the room so that we hear both sides. And sometimes when we get both sides in the room, they look at each other and like, yeah, we'll put our lien to the side while we work this out. But if it doesn't get resolved that way, then the judge is going to say, nope, I'm denying your motion, and they can go forward with it. Or yeah, I'm going to grant your motion, and we're just going to freeze things for a little bit. Jack Bilt, you don't do what you were going to do for a few weeks while we figure this out. So that was a lot. Short of it is you need to check with Judge Edwards and her staff, and they may give you some operating instructions like contact Jack Bilt, et cetera. But they're going to want your case number so they can see what's in the docket. All right. Any questions?
No, that was it. It is an emergency for certain. It would be irreparable harm if they carry out that writ, given that I do have some concerns about the amount in the registry.
Okay.
That's a dispute. But it's a lot of details. I'm sure you don't have time.
That's why we've got Judge Edwards.
Right.
Okay. But you're saying all the right words: irreparable harm, emergency. Those are the kinds of things that would get a judge to say, well, we better have a hearing. Because worst case scenario, even if it is ex parte and we resist that, the judge says, well, let's just freeze things for a minute. And then if Jack Bilt runs into that kind of order, they're going to say, wait a minute, here's our lawyer. Here's Judge why Ms. Shields, she gave you only 1/3 of the story. And then the judge could always just set aside the stay, and then Jack Bilt could go forward. So go talk with Judge Edwards' folks and see what you hear.
All right, thank you.
You bet.
I'm here now, Judge.
Great. Oh, look at that. Okay, so breakout room first, and then Mr. LaChapelle's situation. Annually. All right, they are in. Let me add Mr. Bridges. And Mr. Aurora. All right, I think we've got everyone. And we're going to need you, Ms. Simpson, as well. Let's get on the record, please. This is position 4 on our inquiry calendar, State versus LaChapelle, which is 25 SC 002-666. And we are here today on a motion from Mr. Aurora to modify the terms of probation for Mr. LaChapelle. Mr. Bridges, I received an email last night, and I bet you did too, but I just got to get my hands on it. Oh, we received a lot of emails now too. Yep, you got it. That was very helpful to just frame the issue, the steps Mr. LaChapelle has taken to find housing that is compliant with the conditions under which he needs to operate because of his sentence. And some of the moves I understood. I'll tell you, my eyebrows went up when I saw that the extended stay motel that he had most recently found was on Wendell. We do not let people in drug court stay there. because of that environment. They will relapse if they are there. It's not safe. And so I say that just to frame the issue of we need to come up with something that works. And I appreciate how responsive Mr. Aurora has been, and most of all, that Mr. LaChapelle has simply said yes each time he's been told, you got to move, you got to move. And I would like to find a permanent place, or semi-permanent at least, even if we need to have me enter an order that says, you know what, 922 feet is far enough away. But I'd like Mr. Aurora to start. And Mr. Aurora, you don't need to recap everything in the email, but you are certainly free to frame up what relief you're seeking.
Yes, Your Honor. I also filed a brief. I think I included that in the email on February 17th. And so what I'd put in there under the Georgia code, if the grandparents' home was purchased prior to the church becoming active, depending on how you get there, it could be less than 1,000 feet, but if you drive, it's 0.3 feet or 0.3 miles I put in there. The grandparents have been there for over 30 years, almost 4 decades there. So I think that would qualify as he could stay there, even though it's not his house. So it's a little bit of a gray area, Your Honor. Our goal would be to stay at the grandparents' house as originally planned. The other issue with his parents, what we try to do there is the HOA pool that's within the 1,000 feet. It's not their HOA, it's the neighboring HOA's pool. It's got fencing around it, and you need to have like a code or a pod to get in. It's not like anybody off the street could walk in there. I don't think that's going to be an issue for her. Sam's never been there, never going to go there. And the area that you mentioned is on the list of approved places. I can't find a hotel that doesn't have a pool. I didn't realize a pool was a thing. And so we moved to 4 different places now. And basically, Fulton Industrial is the only place that seems to meet the criteria where the lower level hotels don't have pools. As you know, Mr. LaChapelle doesn't have the wherewithal to understand what's happening out there. And I just don't need him to be victimized. He's staying there. His dad drops him off before it gets dark. But I would simply ask, based on the case law that I've cited, Cobb County's approved it on a couple of occasions on a case-by-case basis. Mostly none of this gets appealed, but these are the 2 I could find from just a few years ago that the chief judge, Ann Harris, had signed off. I don't know if she was the chief judge back then. She is now. So Your Honor has the discretion. And so I'm just simply asking, as we talked about in court, if he could just live with his grandparents, do his job, drive back and forth. We could even take a curfew or whatever you need. This isn't like the child molester type person that these laws are engaged in. As you knew, you understand what the facts were in this case and why Your Honor gave the sentence that it gave. And so I'm simply asking for an exception. I don't know what else to do. Even if the parents wanted to buy him a new home, there's no place near them in Fulton, Cobb, wherever that he could go that doesn't have a pool. So you're basically going to be in the worst areas, living in an extended stay type hotel for the rest of your life or in the country somewhere. And I don't think that's what the intent is, especially not for a disabled individual like Mr. LaChapelle. So I respectfully ask if you could just stay with his grandparents, if you could enter an order, or his parents, whatever the court is comfortable with.
Is there a preference that the family has, grandparents versus parents?
They prefer the grandparents because he spends a lot of time there helping his elderly grandparents, as we mentioned. So that would be choice 1. Parents would be choice 2. He can obviously drive back to the grandparents and help them during the day or in the evenings. But that's our 1 and 2. That's how we would rate.
Okay. And the disqualifying fact for grandparents is the church.
Correct. And so when you Google the Bible Baptist Church, the copyright is from this year, but I have Google searched it. I can't figure out when they started, but his grandparents said they've been there forever, since the 90s. And we don't remember that being a church there or being converted. But again, that would apply if I was the homeowner, right, under 42-115.
Right, he's not the homeowner.
Isn't technically the homeowner, so. But again, I think the case law says you have discretion under limited circumstances based on the offender's age, medical condition, and or the prosecutor's consent. And I think certainly medical condition would apply in this case.
Okay. Mr. Bridges, I'll hear from you in just a second. Ms. Simpson, what is your understanding about a court's ability to say, appreciate your concern, DCS, but I'm going to green light this address?
We primarily have to comply with the special conditions as well as the conditions set by the registry. I'm a little confused because according to Officer Adams, he was living with his aunt when he initially started reporting. And then the aunt decided that she didn't want him living there anymore.
Right, so that's not an option for him.
And so Officer Adams did provide, he provided Officer Adams I guess this is an extended stay in Doraville. And he was waiting for the county to determine if that was an approved residence, but he's not stated as to he was somewhere in the area, meaning living somewhere where he wasn't permitted.
So he did. You weren't copied on the email that Mr. Aurora sent last night, but Doraville did happen. But when he went to register there, it turns out there's a church too close to the Doraville property. And so now he is at this address on Wendell. And you may recall from our last drug court, I never heard of Wendell, but be like, that's Fulton Industrial. And that's the place where we had to tell one of our drug court participants, you can't stay there. Our investigators won't go there. And that's the spot. So I don't think that's a viable option for Mr. LaChapelle.
Our thing is, as long as it complies with the special conditions and as long as they wrap me out with the registry conditions.
Okay. So I need to look at the two cases you cited in your motion, which look like they're Superior Court cases.
Yes, they're Cobb County Superior Court cases. That's
Got
like
it, Judge Harris.
Yeah.
Okay. Mr. Bridges, I'm interested in your perspective on this one.
Your Honor, the state had no position on this. We just couldn't consent to him staying somewhere that violated 42-115. Mr. Adams gave us 3 points of concerns. One was a tennis court, one was a pool, and one was the church. So based on that, we could not consent. I never mentioned this to Mr. Roy, but I did have a concern because as I understand, and probation can correct me, if he goes to Cobb, he has to register in Cobb, correct?
That's what he was doing.
Yes.
Because I only spoken to P.O. Adams, and I know that, and so I was, is P.O. Adams in Cobb?
No, he's with us.
No, P.O. Adams is here. Mr. LaChapelle would have had his supervision transferred. He just hasn't been at it. I mean, we took this plea just a little while ago, and he has bounced from place to place to place. So you're exactly right. Mr. LaChapelle will get a new officer out of whatever county becomes his county of residence. He just hasn't been able to find a location that satisfied the requirements.
And I don't want to tell the judge what their power or anything, but I understand he would have to register with the sheriff in Cobb County, correct?
That's what he tried.
Yes.
So if the sheriff in Cobb County comes back and tells us no, even with the order, we're going to be in some trouble here.
We will, but we don't have the order yet. And I don't want to do an order that oversteps my bounds. I'm going to be interested to see the two cases that Mr. Aurora cited, which conveniently are Cobb County cases.
That's what
and see how that worked. I am familiar with a situation where with the agreement of the prosecutor and the court and probation, a probationer was able to stay with his parents who was working through some of the same challenges Mr. LaChapelle has. And that didn't create a stir with the sheriff because everyone was on board. That was a different jurisdiction. And there's not going to be a case about it. I just am familiar with the situation. But I need to stay in my lane, to your point, Mr. Bridges. And a sheriff might say that's fascinating, but I'm the sheriff and this is the law. But if there's a way that my order provides the sheriff the protection that he would need to say, normally you couldn't stay here, but a judge has ordered it, then everyone can point to the judge if there are bad outcomes if Mr. LaChapelle stays with his grandparents. I'm not particularly worried about those, which is why I'd be inclined to sign an order. I am not inclined to sign an order where I'm telling people to do things I can't tell them to do. So I need to do that homework. And I think that's how I'll leave this. I'll hear from everyone one last time, but I think I need to read those opinions and do a little thinking. My inclination would be, and I wouldn't make everyone reconvene to do this, would be to enter an order, and I'd coordinate with Department of Community Supervision. I might reach out to a sheriff to say, what would need to be in my order so that you wouldn't make Mr. LaChapelle move? And if there's language that works for everyone that I think I have the authority to use, then I intend to enter an order authorizing Mr. LaChapelle to stay with his grandparents. Mr. Aurora, you can finish the research on the age of the church if you want, but to your point, that would be the grandfathering provision, if you will, for the grandparents, not for your client. And so it's an interesting nugget if the church has been there for 10 years and the grandparents have been there longer, but that wouldn't get us onto any of the statutory exceptions.
Correct. And if your honor is so inclined, I mean, usually the sheriff follows it. Otherwise, I just domesticate your order in Cobb County with Judge Harris. And I've cited the 2 cases from Judge Harris specifically because we wanted to go to Cobb. So
right.
You'll read them as you read them. Hopefully you'll see it the way I've sort of written it out, but I'll read it to you.
Well, and if I have questions, I'll just shoot an email to you and Mr. Bridges so that both sides can chime in. I'm hearing Mr. Bridges say, look, we leave this at the discretion of the court, but P.S., you make sure you can really do what you're trying to do. And I respect that. He's right. And I think the right thing for Mr. LaChapelle is to stay with his grandparents, if that is legal. And I need to explore that. So I will do that and let everyone know. Mr. Aurora, anything else on behalf of your client?
Yes, Your Honor. I don't know how long it'll take you to do that since obviously you're busy today. Is there any way we could get like a 1-week exception where he could stay at his parents until we get this resolved versus staying at that extended stay? I don't mean to belittle the area, but this isn't a kind of place that a person like Mr. LaChapelle would. I just don't think he'd be safe there. We've tried it for a day or 2 at this point, but it's a little scary for him. He's sitting here and he's talked to me about it, and I didn't know if I could just get like a grace period, like a self-report kind of thing until you decide what you want to do.
Are his parents in Fulton or Cobb?
His parents are in Fulton, grandparents are in Cobb, so he can stay with his parents or the grandparents if we could just get, however much time you need so he could be safe there, and then we'll decide based on your order.
Okay. Mr. Bridges, anything else on behalf of the state?
No, Your Honor.
All right. Mr. LaChapelle, can you hear me?
It just says speak. You don't need to touch it. They're in the same room with me, Judge, just a different machine, so he's muted. But just talk, Sam.
Yes, Your Honor.
Great. I'm going to allow you to stay with your parents until I enter my order. My order may say I deny Mr. Aurora's motion, and then unfortunately it's back to the drawing board in trying to find a place that is safe for you and compliant with the registry requirements. My order may say you need to stay at your grandparents. Those will be the 2 outcomes. But I can't figure that out right now. And I think the right thing in terms of your safety is for you to stay at your parents' house until I enter that order. So if Officer Adams checks in with you and says, what the heck, why are you at your parents' house? You can direct Officer Adams to me. You can direct him to Mr. Aurora, and I'll explain that I have authorized it on an extremely temporary basis while I sort out what to do with this situation. Okay?
Thank you, Your Honor. I very appreciate this.
again, like my lawyer said, it's not safe. I don't feel safe there. And, I appreciate you looking out for my safety.
All right, well, you can return the favor by making good choices while you are at your parents' house, okay?
Yes, sir.
All right, Mr. Aurora, anything else?
No, Your Honor.
All right, Mr. Bridges, thank you for patching back in. I will let you all know the plan as soon as I figure it out.
Thank you. You all have a good
Thank
day.
you, Your Honor.
All right, bye-bye. Is Mr. Richardson still back there? Maybe they're still talking. If they're still in the breakout room, we can pivot to our 10 o'clock. I don't want to rush them. The young man?
Yeah.
Oh, I was wondering why he was still here. Okay. What's your question about your ankle monitor?
Oh,
Are you having to pay for it?
Yes. We are paying for it. They said that, the order did not state whether the state pays for it or not, so they made us pay for it.
Okay.
This one.
Oops. I don't really know this. Yeah, see.
Oh, yeah, it works. Okay.
Those 18552.
Oh, right. This was we had a visiting judge because this bond order it's funny looking. It's not a normal bond order. So the request is to convert, do you have a wrist or an ankle? Ankle. Is it with second chance? Okay. So the request is to flip the monitor from self-paid to county paid.
Yes, sir.
Do you have this is Mr. Turner still here. This is your armed robbery case. Any perspective on county paid ankle monitor versus self-paid? Okay. All right. I will work with, I'm doing this in another case as well. This is doable. What I don't know is if Mr. Turner, you'll need to go to second chance and just get a different one. Or if they can flip a switch somewhere and then it gets billed to the county. And I need to loop your lawyer in on this. So I won't be contacting you directly. I'll be sending an email to the prosecutor and to your lawyer, letting you know what needs to happen to make it a county funded ankle monitor. Okay. Anything else? All right. My guess is that's what the judge intended, but it was a visiting senior judge and it just says you've got an ankle monitor. Make sure you continue to comply with all the conditions of it. Even if it's county funded, none of the other conditions change.
We'll make sure he does that.
Okay, sounds good.
Thank you.
All right, we have one plea to take and then we will turn to Mr. Johnson's case. And we got Mr. Add spotlight. All right, we got everyone we need. Mr. Frasier, can you hear us?
Yes, sir.
All right, we're gonna go on the record in your case. It is 22 SC 181809. You are charged with aggravated assault and some firearms offenses. You're represented by Mr. Richardson, who is here in court. The state is represented by Ms. Smith, who's also here in court. You, Mr. Frasier, are appearing from Muskogee County Prison. And I need you to tell me if it's true that you are waiving your right to be here in Fulton County for this plea. Is that correct?
Yes, sir.
You are also waiving your right, if we go forward, to have Mr. Richardson right by your side. He's here and you can hear and see him and he can hear and see you, but you guys are not sitting next to each other. Is that correct?
Yes, sir.
Are you okay proceeding with Mr. Richardson here?
Yes, sir.
If at any point during the conversation we're about to have, you want to speak with him confidentially, will you let me know?
Yes, sir.
Okay, then let's get rolling. Ms. Smith?
Thank you, Your Honor. Mr. Frasier, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Andre Boucher Frazier.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
And is there any medication that you would normally take that you haven't been given today?
My blood pressure medicine.
Does the blood pressure medicine make you woozy or drowsy or confused?
No, sir.
All right, and that's the only medication you take?
Yes, sir.
How old are you and how far have you gone in school?
48 years old. I'm 10th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with his services?
Yes, ma'am.
Counsel, are you satisfied your client has a full understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
Yes, we do.
Mr. Frasier, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants related to these charges?
No, we're not aware of any. Other than the initial failure to appear warrant that the court signed when he was in custody and wasn't able to appear at arraignment. Other than that, it's all contained here.
Mr. Frasier, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 10 years to serve 3 with the balance probated?
Yes, ma'am.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you also understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, even on a federal case?
Yes, ma'am.
Are you currently on probation?
No, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm? And that if you did, you could be charged with another felony offense? You
Yes,
said
ma'am.
yes? Okay.
Yes, ma'am.
Got you. Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied your client understands that these are the rights that they'll be waiving by entering this guilty plea?
I am.
Mr. Frasier, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, ma'am.
As to indictment number 22 SC 181809, how do you plead to count 1, ag assault against a peace officer, count 2, possession of a firearm during the commission of or attempt to commit certain felonies, and count 3, possession of a firearm by a convicted felon?
Yes.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a right to appeal to your guilty plea? But if you believe that there is some error in your guilty plea, you can apply to the appropriate appeals court to request a discretionary appeal.
Yes, ma'am.
Do you also understand that this has to be completed within 30 days from today?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes, ma'am.
Thank you, Mr. Frasier. Your Honor, if this case were to proceed to trial, the state would show that on May 7th, 2020, officers responded to 276 Honeycutt, that's HUNNICUTT, Street Northwest, that's in Atlanta, Georgia, also in Fulton County. They're responding to a known fugitive call. When the officers got to the scene, they observed Mr. Dundre Frasier sitting in the driver's seat of a white Chevy Malibu at that location of 276 Honeycutt Street. The officers then attempted to approach the car that Mr. Frasier was in to apprehend him because he was wanted for aggravated assault, robbery by force, and aggravated assault with a deadly weapon. When the officers gave first loud commands over the intercom, he did not respond to those loud verbal commands. He stayed in the car. The officers then approached the car, and at that time, Mr. Frasier started to drive toward the officers. The officers then started to smash out his driver's side window and also spray pepper spray. However, Mr. Frasier continued to drive in the car, trying to drive away from the police officers. Eventually, he did surrender, and he was taken into custody for the charges we have here. After the defendant was taken into custody, the officers searched the car where they found a Glock 27.40 caliber semi-automatic pistol behind the driver's seat on the floorboard. This gun and magazines found were collected and placed into evidence. And those are the facts of the case regarding the charges we have here. Regarding the negotiated plea between the state and the defense, we've agreed to a sentence of, for the count 1, 5 to serve 3 years balance probated. For count 2, 5 years of probation to run consecutive. However, that will be suspended. And count 3, 5 years probation to run concurrent with count 1. And that is all from the state, Your Honor.
2 questions. One, was Mr. Frasier the only person in the white Malibu?
Yes, Your Honor.
2, I'm not following your sentence. I thought it was 10 serve 3 balance probated, but there's a suspended piece in there.
That's correct.
It's the consecutive 5 years for the firearm during.
So is it 2 years probation and then 5 more suspended?
Yes.
Okay, so it's 3 years to serve, followed by 2 years probation, followed by 5 years suspended.
That's correct.
Okay.
I was just saying it as a total amount.
No, it's all good. I don't even know that I'll go with that, but that is, I wanted to follow the, you had said suspended and I thought it was going to be 7 years probation, but it's not. I got it. Thank you. Make sure I understood it. Do we have anyone from pretrial services on the call today? We do. I just saw, there we go. Hey, Miss Hardy.
Good morning.
Good morning. What can you tell me about Mr. Frasier?
There are 40 arrests out of Georgia and Tennessee. 3 felony convictions outside the last 10 years. There is a 2021 possession of methamphetamine with intent felony conviction out of Tennessee. There's a 2023 aggravated assault and possession of a firearm felony conviction out of Georgia. There was an FTA in 2020. Nothing further.
Thank you. Mr. Richardson.
Judge, this is a negotiated plea. The court took a plea with Mr. Frasier. It looks like I'll give you the exact date, July the 21st, 2023.
Is that I found 2 cases. There's a 21 SC and a 22 SC.
22 SC 185505.
Got it. I'm pulling that up. That's the case with Mr. Wright.
That is correct, Judge.
Okay, and we may have taken that when Mr. Frasier was in Tennessee.
That is
I think
correct. I
Mr.
think-
Wright helped us connect with him out of state.
Right. If the court looks at the court's sentence under aggravated assault with a deadly weapon, it was a 10-year to serve 7, concurrent with the Tennessee sentence, and it gives the number 116803.
Okay, I'm looking at it.
So he has been continuously in custody for running up on 7 years now. He's at 6 years and some change, I believe. His max out date is in 2027. His TPM is scheduled for May or June of this year. I guess that's the parole potential release date.
Right.
He and his family made me aware of this case, which the court had placed a judicial hold. I think Ms. Nelson and I looked at it, it was maybe September of either 22 or 23. And that's when I referenced, is there any hold that we're aware of? Just that administratively.
Yep.
Would ask the court to accept the recommendation, considering that he has been in continuous custody. Based on the court's 2023 sentence, there's a 10-year to serve 7. There will be at least 3 years of supervision after his release time, whether it's a max out date or this parole. So if he gets parole in the next couple of months, he'll have a period of obviously probation, and then he'll transition into parole for another 3 years. So we'd ask the court to go along with the recommendation and run it concurrent with SC 22 SC 185505 and a Tennessee sentence according to this 1168032021, and like the court did in 2023. That is effectively all, Judge.
Okay. Mr. Frasier, where is home for you when you are finally done being in prison? Where do you go?
My daughter's house.
Okay, but is that in Doraville or Douglasville? Pardon me?
Atlanta.
In Atlanta. Okay. How old's your daughter?
24.
Okay. Are you done with the custodial portion of your Tennessee sentence, or are you supposed to go back to Tennessee?
I'm done with it.
Okay. Do you have any questions about anything we discussed?
No, sir.
All right. Well, Mr. Frasier, I find there's a factual basis for your plea. Pretty dramatic day on May 7th, 2020, with your white Malibu and the broken window and all that was going on. I also find that your plea is knowing and voluntary, meaning you've understood what we talked about and no one's forcing you to enter this plea. You're doing it of your own free will. Do you agree with that?
Yes, sir.
Okay. Mr. Richardson, can someone in my office sign the indictment on your behalf?
Yes, Your Honor.
Ms. Smith, can we sign for you?
Yes, Judge.
And Mr. Frasier, is it okay if we electronically sign your name to the indictment indicating your guilty plea?
Yes, sir.
Okay. I'm going to sentence you on count 1 to 3 years to serve. Count 2 has to run consecutive to count 1, has to be 5 years. I'm going to probate that. And count 3 is going to be 3 years to serve concurrent with count 1. So it's a total sentence of 8 years to serve 3 years with the balance on probation. You get credit for all the time that you have been in custody since May 7th, 2020. Then you will be on probation for some time. This sentence is to run concurrently with 22 SC 185505. And you'll need to report to probation within 48 hours of your release. Any questions about that, Mr. Richardson?
None, Your Honor.
Mr. Frasier?
Sir.
Okay. Ms. Smith, anything else? All right. Thank you, everyone. And thank you, Muskogee County, for getting Mr. Frasier connected with us.
You're welcome, sir.
Bye-bye.
Thank you.
Bye-bye.
Be in touch, Mr. Frasier. I'll mail you copies as soon as I get my hands on it, all right?
He said, sure.
Man, a few words, sure. Hey, Judge, guess what? I got good news. My daughter got accepted into Georgetown, an American law school, and waiting for Stanford.
Wow. Fantastic.
So I gotta go back to work.
You do. I was going to say, those don't pay for themselves.
Because she finished Cornell.
Yeah.
And she finished American with her, well, she'll finish in April with her master's.
Oh, so that's the American connection.
Yeah,
Because I'm like, Georgetown, American.
Right. Her intent was to go into foreign service, but of course, with the state of foreign service right now, that's not going to work. So she applied to law school, got in, and
fantastic. So she could stay in DC, but maybe get out to the West Coast.
That's correct.
Is she on a wait list, or she just hasn't heard?
She hasn't heard from Stanford yet. She applied for the Knight Hennessy Fellowship, so she made it to the second round. So we'll see what happens with that. If they
Does that help with tuition?
That pays it all.
Ooh.
That's why we're waiting. And
holy smokes!
Right, and there's a thing with American called the PIP Scholarship for public service, and she gets that. They pay for it all.
Oh,
so far
Georgetown's out of the picture.
Well, unless they give money.
Unless they give money.
That was the agreement. We got her out of Cornell with no debt. She got out of American with no. American gave her a full scholarship.
Yeah,
coming out of Cornell.
She's navigating that in a wise way.
Right. So the agreement with her, my mom, her mom, myself, or my wife is that whoever gives her the most money, that's where she's going to go. Because
As long as she's on board with that, she's old enough now. She gets that.
She gets
now. Well, but I like the scene there. It's like, look, they're all great schools.
Right.
She's got a connection with American. Georgetown is great. Keeps her in DC. For
sure.
Stanford.
Right.
So
we'll see.
Yeah.
We'll see. So that's
great.
That's good news. So I thought I was going to retire.
Great news.
Isn't that good news?
Yeah.
Yeah. So
congratulations.
She's excited. Thank you.
You should be very proud.
Yeah, I am, Judge. You know, cook? Yeah.
Yeah, and you really don't have to go back to work.
I know, huh? Yeah. So if she gets a scholarship, it'll be less time. But I'm not built for retirement, I discovered.
Clearly.
Yeah, you know. I sit down and chill with my fingers and fix in my yard.
All right, let us pivot, please, to Alburn Errol Johnson. Mr. Jones is here, and Ms. Williams is here.
Good morning, Judge. How are you today?
I am okay.
All right.
May I be excused?
You may. Good seeing you.
You too.
Wait 1 second, and then we'll get started. Okay, Let's get on the record in Mr. Johnson's case. It's 25 SC 001-305. Mr. Johnson's lawyer, Mr. Jones, is here. And he can see you on that screen. We have Ms. Williams, good morning, for the state. And Mr. Johnson is appearing remotely, which is fine with me. Mr. Johnson, you waiving your right to be here in person?
Yes.
Okay. If you need to speak privately with Mr. Jones at any point, let me know. I don't think today's event would require that, but that's your call, not mine. So just let us know.
Okay. Thank you.
Mr. Jones, my understanding of what we're going to do today is talk about your Bobo motion. You are seeking counseling records related to the child in this case. And you're going to articulate why and why you think they exist. I'll hear from Ms. Williams on that. We can talk a little bit about the logistics of your Rule 702 motion. My recollection was, I put in the email last night, before Ms. Williams was on the case, this has been around long enough, you had a couple prosecutors on it, you had filed the 702 and I had indicated, okay, I'm familiar with challenges to child forensic interviews through the lens of a 702 motion. And I've done several of them and I made the mistake in one of them. Mistake's the wrong word, but I did the experiment of having a hearing and it wasn't productive because it's not a scientific, well, wait, you added cadmium to the formula or the tensile strength of steel is this. There's an interview and there's an application of a rubric that experts have. And what I quickly found was really the way this works is not that I would ever exclude it, but you would be able to cross-examine this person on his or her qualifications, and then the faithful application of the child first model or whatever it is to the interview or interviews, because it sounds like there may have been two, all of which would happen in front of the jury anyway, because all of it is impeachment of that expert's credibility. And so what we had in the hearing was a back and forth about did the expert do a good job? And that's really a question for the jurors in the end. But because it's not what I'm gonna call hard science, unless there was a complete absence of an application of whatever rubric, child first or whatnot, there really wasn't anything that would be suppressed, semicolon, if there was a complete absence of it and the interviewer was constantly leading the child and asking suggestive questions. That's actually a phenomenal interview for the defense. And the state probably wouldn't want to use it, and the defense would. So I don't know that you would seek to suppress that. But in my experience, the interviews that a defense attorney is trying to keep out through 702, which I think is a stretch with 702 in that setting, are ones where there really were no issues and they're problematic for the defendant. And why not try? It's not a critique of trying to do that. It's just my observation that we're in a space sort of like if we had a cell site expert. That cell site expert is sharing with us knowledge that he or she has about how cell sites work. And it's really not, you're kind of forcing through the round hole of 702, a square peg of what I call more of an educational expert, as opposed to a scientific expert, which is not to say there's nothing rigorous about what these people do. It's that 702 really isn't designed to exclude experts who are working in the softer sciences. But I'm gonna let you address all that in a minute. We're gonna start with Bobo. I'm just teeing up the two things I think we're covering today. But I don't wanna make that the exclusive list. Were there other things you feel we need to get through so that we can all say, State versus Johnson, ready for trial, which it needs to be. And it has taken a while, not because of the lawyers. I have, because Mr. Johnson has been on bond and I've had people charged with murder in jail, it has slid back in the queue a little bit longer than I should have let it. But here we are.
Yes, Judge. Just only a couple things to add. I wanted the court to know that the defects order is with Muskogee County defects. So just waiting to get back whatever records are associated.
And they've got a deadline, and I'll certainly let you know if they say we've got nothing. I'll share that with everyone. If they've got something, then I'll let you know that that I'm doing the in-camera review.
Right. And in terms of the records we're seeking to get access to, unless the state has information that the mother of the alleged victim or stepfather also is potentially in therapy or treating, what the court has outlined is all the records that I'm aware of or that may be at our disposal at some point in the future.
Okay. And when you say you're aware of them, you are theorizing that the child received some type of counseling or psychological or psychiatric care, or you know it to be true, and we need to work through the process of, if appropriate, getting those records to me for review and then deciding what happens with them from there.
The latter. We're positive that the child did receive treatment in connection with her allegations.
Okay.
I'm not, however, positive that the mom and stepfather have received treatment, which, you know, may be relevant depending on the purpose of that treatment. If they even sought any, I'm not sure. But that's just a question that's still out there, but the alleged victim definitely received treatment.
Okay. All right. And tell me what you think is the justification that would pierce the patient doctor privilege to get you, let's assume for a moment it's just the child, that would get those to you.
Absolutely. The outcry was made in January of 2023, and the alleged victim began treating almost immediately thereafter, February 2023, with a Dr. Tori Young, and again in August 2025 with Miss Richardson, Yvette Richardson.
Do you know if the first doctor was Dr. Young?
Dr. Tori Young.
And the second doctor was Richardson?
Yvette Richardson.
Okay. Do you know if treatment with Dr. Young was continuous until the pivot to Dr. Richardson, or it was for a few months and then there was no treatment, and then for some reason 2 years later there was a new batch of treatment?
That I can't answer. My understanding is that she treated with Dr. Tori Young from February of 2023 until December of 2024. And then other information I have is that there was a gap between August of 2025, and I'm not sure when treatment with Dr. Richardson ceased. I'm not sure if there was other treatment in that intervening period between the end of 2024 and August, but that is the timeline.
Got it. So Dr. Richardson started in August of 25.
Correct.
Okay. And how is it you know who the doctors were and the duration of the treatment?
Yes. The mother provided these doctors to prior ADA, and it was in an email where it's kind of a table of the doctor's dates. And
So the prosecutor shared it with you?
Yes.
Got it. Okay. I'm not saying you shouldn't have it. I'm just curious how that came to be. But it's also helpful. We know the universe of what we need to look at. It sounds like. I mean, we'll need to confirm if I say the state does need to move forward, that there are no other doctors. Okay.
Absolutely.
All right.
And in terms of the treatment, I think definitely everything after January in 2023 would be relevant because it's directly related to the outcry, at least as far as I can tell. With Dr. Tori Young, I don't know what would have been discussed with Dr. Richardson, but I would assume it would be along those same lines given the time frame. The alleged victim did also treat with two other providers prior to the outcry. One as early as 2018 or 2019, and that was Dr. Allison Barrero Jones, and then also Dr. Donna Kemp from May to June of 2022. Now, admittedly, I don't know, exactly what was going on with those two, so I wouldn't be asking the court to allow me to get into a fishing expedition per se, but given what Bobo has outlined, in order to get past that mental health privilege, I have to show on behalf of my client that there's a necessity, and the evidence in question, of course, is critical to our defense, which is the first prong, and the second one would be that substantially similar evidence is otherwise unavailable to him. And you got to make the prima facie case, and underlying all of that has to be relevant. So we're not seeking to get into her entire psychiatric, profile or whatnot, only insofar as it relates to, one, either her treatment for her alleged allegations, and whatnot, or if it pertains to any mental state that would affect her credibility and her ability to narrate, tell the truth, recall, things of that nature. She's going to be the only person who can give this jury information firsthand. And we can't assume that, Mr. Johnson is going to take the stand and testify. And there's nothing in the discovery that says there are other eyewitnesses. So the jury is left to basically determine if what they're being told by the alleged victim is the truth. And if there are any mental health diagnoses that I'm unaware of that affect her ability to tell the truth, or for her to recall events and for her to, give a cohesive account of what happened, then I should be allowed to get into that for that limited purpose. In terms of the mental state, there is a case on point, United States v. Lindstrom, Lindstrom, 698 F. 2nd, 1154. That's from the 11th Circuit, 1983. And they're basically recognizing that some mental disorders can affect the witness's credibility while others do not. I'm not saying that, the alleged victim has a mental disorder, but if she did, and depending on what that was, they could have an effect on all those things I just mentioned. So those are the types of things we'd be looking to get into. And we'd be fine with the in-camera inspection, as opposed to just obviously giving over all the records to the defense, which could be problematic for reasons the court is already aware of. And there's a necessity for this. We have literally no other way to find out if these things are actually present with the child. I think that is, definitely relevant that she was already in treatment. And, would I like to know what she was being treated for and get those records? Sure, but I can't, say to this court that they're directly in relation to this. I know that, therapists and doctors have that mandatory responders that they would have to report. So we could assume that if they're competent, that there's not going to be any allegations of child abuse in there. But we couldn't say with certainty that there is no mental health diagnosis and whatnot. To be fair, she would have been like 3 years old in 2018. And a lot of this stuff doesn't really show up until, teenage years and whatnot. But I'm not the expert. I don't want psychologists telling me how to do my job. I'm not going to pretend to know how they do theirs. But there could be something there that's at least worth exploring, at least from our point of view and what the case law says. In terms of just getting the records, period, just the medical records. Donaldson.
When you say the medical records, meaning the reports of treatment from Dr. Young and Dr. Richardson.
Correct.
You're not talking about, and by the way, the alleged victim went to a hospital for an examination. That's not what you're talking about.
Well, potentially. That is kind of, if you would, a last resort. If the court isn't going to allow us to delve into the psychiatric treatment, there is a case that says we can get just the medical records in as much as they're not privileged. And that is Donaldson, D-O-N as in Nancy, A-L-S-O-N v. State. And that is a 192 Georgia Court of Appeals case 37 from 1989. And from that case, it says that psychiatric medical records are not absolutely privileged, and that in response to a valid subpoena or order of any court of competent jurisdiction, you're allowed to get that information, just the medical records from a psychiatric, stay or whatnot, so long as they don't contain privileged information. So that could be a redaction as a fail-safe. But I think that we're on solid ground here to request this, and we've made the prima facie case. I don't think the state is going to say that the treatment with Dr. Tori Young in 2023 in February was not in relation to the outcry. And if, I'm not just seeking general information, what she told the doctor was, different than what I expect her to testify to at trial. I'm specifically seeking anything with the diagnoses that affect her credibility and would thus affect my client's Sixth Amendment right to confrontation to get a full exploration of that credibility. And also, we can't get this information. anywhere else. So that's generally the idea. That's the case law. Of course, the court is familiar with Bobo. There's another case, in Ray Frost, where it was ruled against the defense in terms of getting the records. But the reason that the court found it unpersuasive in that case was because they weren't able to relate it to the charges at hand. It was a mother who was accused of child molestation, if I'm remembering correctly, and her defense counsel just basically sought to get all of the records, and they were not able to assert that it was in relation to the outcry. And the court found that that was just a fishing expedition, and that's in Ray Frost, 366 Georgia Court of Appeals, 45, 2022. So yeah, that was a stepmother rather was charged with child molestation, cruelty to children, etc., and was attempting to get just general records. The child, I believe, was just treating generally at the time before or during the outcry, and it wasn't in relation to or subsequent to the outcry, or at least that was not alleged by defense counsel. In that case, I already gave the court United States v. Lindstrom. Just to kind of go into that a little more, it was a federal mail fraud case. There was a witness who had a grudge against these defendants and had a mental health history. She had, I think, a couple of suicide attempts and some other things. But in that case, it was her credibility that was in question due to some medical psychosis that she was going through, and they were not allowed to, or severely restricted in their ability to cross-examine her on her mental health issues or to get access to those records. So that is generally my argument, Judge.
Okay.
Thank you.
You're welcome. Ms. Williams.
Yes, Judge, just one moment. I'd like to share my screen.
Sure. The project I had for you has already been completed by, really, it sounds like your predecessor, but Mr. Jones was able to say, yes, I know there was treatment here, the treating professionals. So we know that. And it's just a question of, is that something as a threshold I need to look at? And then ultimately, would Mr. Jones have access to? So.
Your Honor, if I may approach?
Sure.
I have a courtesy copy citation packet.
Thank you.
So at this point, the state does oppose the release of these records pertaining to Ms. Roy, Mr. Roy, and the alleged victim. We believe.
So I'm following the names. Ms. Roy would be mom.
Yes.
And then stepfather is Mr. Roy?
Correct.
Okay. And we know who the victim is.
Right.
All right.
And so what we're asking basically is that defendant's motion be denied because it's overly broad. It doesn't lead to evidence that's critical to the defense. Issues of credibility and reliability can be reached in other ways. And to the extent that, the court would be inclined to grant the motion, we do ask for restrictions and limits.
Okay.
So,
Before you dive in further, and I promise I'm gonna let you go through all this. What's the response to the hypothetical? Well, how do we know that the child didn't tell Dr. Young, it never happened, my stepdad is telling me to make this up? Let's say she said that to Dr. Young. Gosh, that's disclosable. That's highly exculpatory. And I think that not providing that to the defense would be a problem. Not that you would sit on it, but that it should be looked for. If in fact, the reason why the child was interacting with Dr. Young was because of the outcry. And the only way to know if the child said, it never happened, my stepdad told me to make it up. I'm making this up, I want to be clear. But when you say that Mr. Jones hasn't been sufficiently specific or articulated a need, as I understand it, and this may be where you're going, the universe of evidence about what happened will be child hearsay, what the child told others, and what she tells the jury. Of course, she'd have to be able to testify, if available to testify, if these other people are going to say things about it. So there are things that Mr. Jones will get, but it will be your witnesses, and he won't know. But what did she tell the doctor just a month after it happened? And if that happens to be different in a material way, not that it hurt a little versus it hurt some, you know what, that's not disclosable. But it didn't happen. The only way we know that's there is by looking at those records. Whether it's you looking at the records or the court, it is never a wholesale, hey, see what you can find in there. So safeguards are a certainty if there's going to be any review of the records. But I wonder, and I'm gonna, I guess, get out of your way, in the Bobo context, absent, they're like, well, but there was another treating physician who is available, but there's still, we don't know what the child said to this doctor unless we look at those records so that we can know it was generally consistent. There wasn't a description of what happened that was radically different.
So I'm gonna kind of stay in the universe of child cases.
Mm-hmm.
So in child cases, a pediatrician, a mental health provider, those are all contexts in which children may disclose. So for child cases, that the potential that the child could have said to somebody, this never happened, that would eviscerate that patient provider privilege in child cases, because it could be possible. In the world of possibility, that could happen for any eyewitness of any crime. They could be in the middle of therapy and say, hey, I'm going to testify in this armed robbery trial, but you know, I didn't say anything. I wouldn't, you know, I'm just making it all up. That would eviscerate this privilege. So that's why Bobo is exactly in place. And it's particularly important for child cases because these types of offenses, in a general view, often do not have eyewitnesses. So that's why it's very important. Otherwise, you would constantly and consistently be calling in pediatricians, counselors, school social workers, teachers, dentists even, to testify that there was nothing said to that particular provider or adult, basically, that controverts the allegations.
Well, except you wouldn't need to bring someone in, and I don't know how Mr. Jones would, I don't know why he'd want to, but how it would be relevant. If what the child told Dr. Young is essentially consistent with what is on the forensic interview, then Dr. Young is not relevant, and those records aren't relevant, and they would not be disclosed to Mr. Jones. I would look at, you would look at them, and I would look at them, but there'd be nothing to disclose. The question I have, I didn't ask it well, is why shouldn't it be, given what we've heard from Mr. Jones, that, yeah, you know what, you've described a channel where the child may have discussed what happened, and it's the state's obligation and the courts to ensure that there's nothing exculpatory in there. And either we determine, it's just a funny coincidence, but the child never talked to Dr. Young about that. The child was having nightmares before this incident and was still talking about the nightmares that involved some, she got bit by a dog when she was real little. And so there's nothing there. But it's not a fishing expedition, I think, if there is this linkage in time between the outcry and then the treatment follows right after that. I guess one way you could show that it is a fishing expedition would be if Ms. Roy or Mr. Roy shared with us, no, that's not why she went to see Dr. Young. It was something different. And it's none of his business, but they might need to disclose to me, hey, she was bit by a dog 6 months before. And this was just a continuation of therapy because we actually breed dogs. And it's awkward to have her be scared of dogs because we need dogs to be around. I don't think that's this case. But I don't know why we assume away the fact that the child could have said something very, very different to this treatment provider. It doesn't mean that person necessarily even needs to come in. It means that there's an obligation to look. That's how I see this, is that the threshold to, it's because it's just like defects. Mr. Jones will see no defects records if they aren't relevant to these allegations. But simply by saying, hey, I want him, he gets that door opened. And to me, this is similar. The question of whether he gets access to them, that's the protection of Bobo. Just because he is pointing out this chronological connection. Outcry, Dr. Young. It's not unreasonable to say, the child, is probably talking to Dr. Young about what happened. I get those records. Well, no, you don't. You don't get those records necessarily. One, she could have been talking about something else. Two, more likely, she was talking about this situation, but she's not saying anything different. So you don't get it because it's protected. It is doctor and patient, and there's nothing new. In fact, there's not a need for it because just press play on the forensic interview, and then you are hearing what she told people. So that's how I view the Bobo. The real rigor of it is, does it get past you or me as the reviewer who would be looking for exculpatory information? But I was hearing you say, and it's the only reason why I cut you off. I did a bad job of letting you dive into this. What I was hearing you say is, you know what? I don't, meaning you, I don't have to get the records and look at them, Judge. You're not allowed to get the records and look at them unless Mr. Jones shows something more. I don't know how he could show more being on the outside of that, appropriately on the outside of the patient doctor or parents and doctor relationship.
And that is true. But again, in the context of child cases, many of our victims are receiving treatment. And this would eviscerate that privilege for them. The privilege belongs to the patient and secondarily to the provider. So it rarely happens, of course, because the state is prosecuting the case, but a victim could ostensibly say, I don't want you to see my psychiatric records.
And that's a key difference, and I'm kind of familiar with the DiPietro case. That's a big difference from DFACs, because those are not privileged. And it's not like the parent can say DFACs don't disclose. It's just things that are discussed are sensitive. And so you can get them. You just have to ask. The state can always get them. The defense can't. They have to be filtered through, appropriately so, because there could be something going on with another kid that's embarrassing and is kind of impeachable, but it's not relevant to the case. The difference here is the privilege that exists. Okay, back to you.
Okay, so of course, we're asking whether or not the privilege is going to yield or not to the right to confrontation. And as Mr. Jones did state, the case law standard is that the defendant has to make allegations that demonstrate that need. Otherwise, it's a fishing expedition. So just to sort of, and we just kind of talked about this idea that the whole purpose of the privilege is to encourage the patient to talk freely without fear of disclosure and embarrassment. So that changes, I believe, a bit the lens through which Georgia examines whether or not the privilege yields. So here, I just want to make clear that the privilege does apply, that they did seek the mental health assistance voluntarily, and that any records, recordation were created in the course of treatment. And those cases are in the packet. So we're back here. So that privilege does apply here. So now we need to see if it's going to yield based on a demonstration of need. So it has to be necessary and critical to the defense. Again, Mr. Jones did say a couple of times, he said that he doesn't know if the victim has a mental disorder. There is no demonstration. There is nothing showing or suggesting that the victim does have any type of mental disorder or defect or whatever that would affect her ability to narrate, recall, or be credible. And in this situation, substantially similar evidence is available. The forensic interview is going to be played. Both of them, they will be played. Okay. So to the extent that there is to the extent that the victim is available, the jury will be able to observe. I would obviously direct the victim on the stand. Mr. Jones would have the ability to cross-examine. The jury will have 3 opportunities to hear from the victim. So credibility is always for the jury to decide. So I believe that that evidence is available to him. So we're back to this. I spent a lot of time on this, so I'm gonna use it a couple times.
No, that's fine.
So we've talked about how the evidence is not necessarily critical, but usually we're looking for, as you've already said, Your Honor, exculpatory evidence or things that would lead to, that would impeach the witness. And as I said, and this is just a quote from Mr. Jones' motion. So it's simply ability to recall and narrate. There's no specific allegation that the victim has ever demonstrated before a problem with that. And to the extent that we're talking about credibility, which is recall and narration, again, the victim will be available for cross-examination. So Mr. Jones did cite State versus Williams in North Carolina. And that case is a little bit distinguishable because it focuses on the specific instances of drug use or mental instability that may bear upon credibility to cast doubt upon the capacity of a witness to observe, recollect, and recount. And there, and that case is in the packet as well, the defense made specific allegations about circumstances and conditions that the witness had that would call into credibility. Here, there's been no allegation. There's been no proffer. And we do understand that the witnesses and the victim would be critical for the prosecution. So to the extent that they would be called to testify, they will be available for cross-examination.
Do you believe that the state has an obligation, probably under Giglio and progeny, if you knew, again, making this up, if you knew that, and say Ms. Roy was going to be a key witness to talk about, this is what my daughter told me, and she's acted differently post-outcry than before, and you learned that Ms. Roy is a pretty serious drug addict. Is that disclosable to the defense, that she has this issue that could impair her ability to recall things? In fact, you've interacted with her at times and she's like, hey, and she can't remember your name. And like, I'm kind of worried you're strung out right now. Is that something that would be disclosable to the defense because you've got evidence that there is a situation in Ms. Roy's life, fictional, but my hypothetical, that impacts her ability to relate to you? It had impacted her ability to relate to you, what she recalls and what she's perceiving. And it's your belief that, in fact, at the time that the child made an outcry to her, she was still an addict, an active addict. Is that just awkward for you, or is that disclosable to the defense?
Your Honor, for me, that is far greater than awkward. That would really go to the heart of whether the case should be prosecuted at all.
Well, but let's say the forensic interview is solid, because it's not that the victim have this. It's just there's this situation with mom. And so you're going to call her because that was the initial outcry. But you now, it's not just a concern, you know, uh-oh, she's in active addiction. And some days she knows who I am and some days she doesn't. And you're hoping when she comes into court, it's a dry day. But is that a disclosable situation because it's come to your knowledge?
It could be potentially, particularly if there's any issues with criminal history, that should be disclosed. And I think that generally, if I believe that the witness's ability to recall is based on a drug-fueled fantasy, that yes, that should be something that I would discuss with the defense.
Okay. And if what the basis for the inability to recall or the shifting ability to recall is instead a mental illness, but you somehow learn about it, it seems similarly you would disclose that to the defense, that, look, mom's going to testify and we're going to have her talk about it, but I want you to know in advance that she struggles with these issues. And we, the state, have concerns about the reliability of her testimony because she's schizophrenic. She hears voices and sometimes she's on point and sometimes she's not. But we need to call her as a witness because she's a key in the chain of events that led to getting the victim to the forensic interview and to law enforcement.
Okay, I'm glad you said that second part because struggles with an issue is different from affecting one's ability to recall. So
Let's go with the latter.
right. So to the extent that I believe that it would affect her ability to recall, it would definitely be something that I would disclose. It would definitely be something that I would bring out during testimony.
Okay.
To make clear.
All right.
And again, I just really want to underscore that if what we are doing is looking for the absence of evidence of a condition, that's a fishing expedition. So, and this pertains more to the actual testimony of a doctor, but I believe that it does go to the issue of being able to examine credibility.
Right, because in DiPietro, they wanted to get the doctor on the stand, and the wise judge said, you don't get the doctor on the stand. And then the even wiser Court of Appeals said, trial judge got it right.
Right, exactly, because credibility, as long as that witness is available for testimony and available for cross-examination, credibility can be reached in other ways. And as I said, we will be showing the forensic interviews. And so here we have Easter versus State, which is in the packet. And this is about mental conditions. Defendant has not shown that the victim's mental condition or treatment was relevant to or affected the credibility of her allegations. In the absence of such evidence, defendant has failed to demonstrate the required necessity to obtain victim psychiatric history. And so I believe that's the situation where we are now. What we're saying is there could be something that maybe could affect the victim's ability to recall or narrate. We're not sure. We haven't seen anything demonstrated in victim's behavior ever. The forensic interview has been made available to the defense, and I do not believe that there is anything in that interview that would lead anyone to think that there is a problem. So,
well, and Easter gets to the point I was engaging Mr. Jones on, which is not so much that the child is working through a mental health issue. I've been working through a lot of PTSD if this happened to her, but it was the first part that the defendant speculates that the records would show that the story was different. That's really what I was focused on, is what if the child told Dr. Young it didn't happen, or there were 3 people there, and everyone else, she said, it did happen, or there was 1 person there, and it was just Mr. Johnson. That speculation that maybe she told not just anyone, not her uncle, because you can call the uncle, but this protected relationship, that this counselor, this therapist who's here to help you, the speculation that the story might have been different under Easter is not enough to get at those records.
no, it's not.
Okay.
And here we are, the chart again. So I believe, Your Honor, that for this chart, we're at fishing expedition. I don't believe that there has been a demonstration that these records for the victim, for Ms. Roy, for Mr. Roy, could lead to evidence critical to the defense that's not available through evidence that's already discoverable. So for those reasons, we would ask that you deny the motion. And this is Plant. And this speaks to impeachment, again, for credibility. Credibility can be reached in numerous ways. And the subpoena is not an instrument of discovery to try to figure out if this could exist. So what we're asking for a full denial, to the extent, Your Honor, that you would be inclined to grant the request. If anyone is going to be called to testify, we would like for those individuals to be voir dired prior to trial so we could figure out what their testimony would be. They could receive their limiting instructions, et cetera. To the extent that you would grant defendant's motion, particularly for Miss Roy and Mr. Roy, because they're adults. They've got a whole lifetime of experiences. We really need some very strong limits. As you said, people could be dealing with things from military service or anything else. So we need some very strong limits on those requests. And then to the extent that, of course, you would grant the motion, an in-camera review of obviously would be appropriate. All right. Thank you, Judge.
You're welcome. Thank you for that, and thank you for this packet. Mr. Jones, as the movant, you get the last word. Anything you want to say in response?
Yes, briefly, Judge, thank you. Of course, our position is that it didn't happen. So if the alleged victim is making this outcry, then there's some reason that she's making this up. And we don't know what that reason is. Given what we've heard so far, it's not outrageous or us just looking to comb through the alleged
I'll be clear,
victims.
none of this is outrageous. You are legitimately seeking to defend your client. Well, getting into the parents' records is getting closer to the, hey, I don't know about that, but wanting to understand what's in these records, I don't think is outrageous. It just may not be authorized. And that may be where we are, but I understand the reasoning behind it. So you don't need to defend it in that way. I get it. It's just, it may be that the privilege doesn't allow for that.
Yeah, I understand what the court may be saying, and the privilege is not sacrosanct. It can be pierced, and it doesn't totally trump my client's Sixth Amendment right to confrontation.
Well, that's the collision, is the privilege and your client's constitutional rights.
And it is of note that she was already treating with these doctors prior to the incident. That's not totally irrelevant, you know, in terms of what may be going on with her mental state. It's not as if she was, by all accounts, somebody who was in no need of therapy, had no issues that needed working out, and then all of a sudden there's an outcry and now she's in therapy. She's already in therapy since she's about 3 years old, and then there's an outcry when she's about 7 or so, and it's more therapy. So I think that deserves at least to be explored by the court to figure out what that mental state may be, if it bears on her credibility. You know, we've all probably read several reports dealing with juveniles. I actually started out in juvenile court, so I've read a lot of juvenile reports, and you hear and read things where the doctor is saying this child embellishes and has a, you know, tendency to lie about this, and they have this relationship with their parent that causes me to doubt what they're saying here. So all of that, those are things that I would have no way of knowing and have no access to if they are in fact in the report. I can't get that information. Even if we were to call these witnesses at trial, who's to say they won't get on the stand and attempt, you know, not to answer and assert a privilege? I mean, if I'm cross-examining the alleged victim and she's been told that she has this privilege and I can't subpoena these doctors and get a hold of them for whatever reason to bring them to trial, and the state doesn't bring them to trial, it's just impossible for me to get at that information. And it'd be more economical to handle it before trial. We need to subpoena these doctors and have them come and ask them these questions. We could continue this and do that at a later date to determine if it's relevant and if it bears on her credibility and outside of the presence of a jury. And then maybe we could save, you know, 2 or 3 of these doctors who treated the alleged victim from even having to come to court and be subject to a subpoena at a trial. So those are things I like the court to consider and to grant the motion in terms of at least an in-camera review to figure out if these things, if there's exculpatory material, then great. Or if there's, you know, mental health concerns that affect her ability to tell the truth, great. And if not, I never get to see anything. So that's my position on it, Judge. Thank you.
You're welcome. Thank you. I will take that under advisement. The Rule 702 motion, is there anything you want to be heard on right now? Not in terms of is it meritorious or not. I've described the process, which involves, I think, getting a thumb drive from you, Ms. Williams, either today because you brought it, or you can have someone bring it by whenever. And it sounds like it's 2 interviews.
Yes, Judge.
Same interviewer?
Yes, Judge. The same interviewer both times.
What's the theory behind the 2 interviews?
They're 8 months apart. One's in February 2023, the other one's in October, and they, according to the reports that I've seen, wanted to figure out where the alleged incidents happened. Was it
Okay.
Columbus, or was it all in Fulton County, or was it somewhere else?
Okay,
That's
helps
what
with
they said.
venue.
Yeah, that's what they said.
Okay, so there's one right away, and then there's one a little bit later on that sounds like is focused on where, as in geographically. I mean, you've listened to it, I haven't.
Yeah, yes.
Okay.
Yes. To
All
answer
right.
your question.
But importantly, it's the same interviewer. So if that interviewer is deficient in some way in her or his application of techniques, we just got one. We're not like, well, this was the expert and this person was their first interview ever. Okay. All right. Then Ms. Williams, if you can get those to me, that would be great. I will review them. And then, as I mentioned in my email last night, if I have questions or concerns, I'll reach out. Mr. Jones, if you've got parts of the interview that you want me to be particularly keyed in on, I'll watch both in their entirety. But if when you watch them, when you got to the 8-minute mark, like we got to do a 702, this person has completely abandoned it. All they're doing is saying, and did he do this to you? And suggesting answers as opposed to saying, what happened next? How did you feel about that? You should bring that to my attention so that I'm keying in on what you're keying in on. If something like that happened, you may just not like the child first protocol.
Then I just include the state on any of those communications with the
Yep,
court.
yep, yep,
I'll
yep.
definitely do that, Judge.
Yep. Last question I've got right now for you, Mr. Jones. I think you've answered it, and it may be, actually, Judge, this needs to be ex parte. As I am evaluating the Bobo motion, I need to make sure I understand what your defense is, because if I'm misapprehending it, then I may look at it and say, that's not germane at all. And you would say, well, no, actually it is. It sounds like the defense is, it didn't happen. So it would be then relevant if the victim is describing it in a different way, where her credibility in terms of her description of what happened can be called into question.
Yes, Judge.
Okay. All right. I think I've got everything I need. I don't remember what the deadline was for DFAX materials, so.
It's the 13th of this month.
And I'm not going to remember what it is. And so you should shoot an email to me and Ms. Williams saying, hey, it's the 14th. Did you get those records? Because if the answer is no, then I need to reach out. So I'm going to rely on you to do a check-in. I can say, yep, I got them. And it's going to take a while to get through them, or I got them and I've looked through them. You should come by. There are 15 pages I set to the side that you should be able to review, or there's nothing in there for you.
Sounds good, Judge.
Okay. All right. Let me see where. We are on a calendar. Okay. The next calendar that we could put this on for trial would be the one that's at the end of April. That's when we call the calendar. I think trial is actually on into May. Any issue with that, or do you want the specific dates, Mr. Jones, so you can check your calendar? What I don't want to do, Ms. Williams is always busy, and so I just fight with the other courtroom she's in. But if you like, hey, I have a 2022 case specially set, there's no point in putting Mr. Johnson's case on that calendar because you wouldn't be available.
What dates would the actual trial be in May?
Let me look.
Okay.
So we call the calendar on the 23rd and the week of April 27th. So last week of April, which includes the very first week of May. And then it's just a 1-week calendar. So that would be that week of April 27th. And I can get my business done in time for that if that's a week that you're available. I'm not saying I'm specially setting it, but I will certainly put it on there, and it's getting to be one of the older cases. So it's one that we would focus on.
That would work for me, Judge. I don't have any trials that week. Only subject to our experts' availability, because
Okay.
I do have an expert that we are working on securing, so that would be the only caveat for me.
Okay, well, as soon as you know that, you should let us know. That calendar won't be published for a while, and I'm fine pulling it off the calendar. But then we may need to start talking about specially setting it to lock in the expert. Ms. Williams, right now, that week of the 27th, you supposed to be in 5 other courtrooms, or you're okay?
No, Your Honor, to my knowledge, I don't have anything specially set for that time period, so I would be available. Of course, we do have an expert, the forensic interviewer, Ms. Riddle. She is out of state, so I would need to secure her presence.
Okay.
I will begin to inquire about that now.
Okay.
And let you know as soon as possible.
Great, please do. There's one forensic expert who moved to Colorado and won't travel with her kid for 2 years and that's not the same person?
No, Your Honor.
Okay.
This is a different person.
Good. That has made your unit's life very difficult.
Yes.
And some judges very frustrated. Not this case. Good to know. Okay. Mr. Johnson, do you have any questions for me, or have you been able to follow along with what's going on?
I've been able to follow along.
Okay. Well, thank you for joining us. I will take all this under advisement, and I will look for a thumb drive. If someone's not in chambers when you come by, if you just leave it in an envelope and clip it to the little box, I'll get it that way.
Thank you, Judge.
Thank you. Then I think we're done. Thank you, Ms. Rivers.
All right, thank you, Judge. Have a great rest of your day.